and having a robust discussion, hopefully, after. Let me share my screen for everyone. Okay, so today I've been asked to discuss social media, or actually revisiting social media policies, implementation of social media responses during the pandemic, although maybe I should call it post-pandemic, and what I refer to as the political divide. There is a well-known quote, often widely incorrectly attributed to a Chinese curse that says, "May you live in interesting times." Regardless of the origin of the quote, I think we can all agree that we are certainly living in interesting times. It's sometimes hard for me to believe, and perhaps you, that it's been well over 15 years since social media really took off, with MySpace in 2003 and Facebook in 2004 as the leaders in the industry. It's 2021 now, and you'd think that the legal issues that social media has forced those who represent employers and employees, those who are government agency people who enforce laws, and of course, decision makers like arbitrators had to address. And you'd think those issues would have diminished. But as we'll discuss throughout this presentation, the issues that started like water leaking from a pipe are now a full-blown hose. As Robert said at the outset, I am Adam Forman. One of the things I've noticed throughout the pandemic is that we've all participated in enough of these video meetings to know that many of you are going to probably tune out of my presentation from time to time, and that's okay. I might tune out also. But if you decide to take a quick mental break, I would ask that you consider connecting with me on social media. This is my social media LinkedIn handle. As always, when I do a presentation, I try to blindly accept all connection requests within 2 hours after my presentation. So if you're a recruiter or you're spamming me, you're going to get in my network anyway, as long as it's 2 hours after my presentation. If you are someone who's on Twitter, feel free to tweet about my presentation. Here's my Twitter handle. And if I've always tried to be as diligent as I can. Maybe I shouldn't be, but one of the reasons you may want to connect with me is that my firm puts out a lot of really good content. We have Take 5 publications, which have 5 short summaries of legal topics, often by industry. We have Act Now advisories that'll update you on alerts of things you need to be aware of. We have announcements of our products like our halting harassment, which is our e-learning solution. And then the thing I think we do perhaps the best that you may be interested in is something called Employment Law This Week. It's a weekly 5-minute video that summarizes the top current labor and employment stories. And the last 30 seconds are dedicated to some in-house attorney or government agency official, if they're permitted to speak, who provide a practical tip or pointer from that side of the house. And it's really helpful for labor and employment law practitioners. And of course, if none of this is interesting to you, feel free to connect with me on Peloton. I've been doing it all through the pandemic. Is wonderful. Here's my handle. I'm Frugal1, or you can use the hashtag #WorkWithEVG. All right. So I thought for today's discussion, I would break it up into 3 parts. The first is going to be doing some level setting, where I'm going to show you some examples of social media posts that have occurred over the last year that both touch on the issue of the pandemic and the political divide. Then I'm going to walk through some of the legal issues that may present themselves as these posts appear, and decision makers are required to respond to them, whether you're on the plaintiff side, the defense side, whether you represent unions, whether you represent management, or whether you're an arbitrator and has to make decisions based on social media posts and conduct. And then finally, I wanted to carve out some time to have a discussion. Certainly examples, questions, all that is fair game, as long as we keep it anonymous and not disclose any names or people. So for the level setting part of my discussion, one of the things I'd really like you to consider is how you personally, in your own capacity, would respond if you were asked to deal with some of these posts. So if you represent an employee who perhaps was subject to adverse employment action because they posted this conduct, perhaps you're the employer or HR person and you've got to respond in a uniform, consistent way. Perhaps you're a government agency and you have to determine whether anything in the post would give legal protection. One of the first things that happened at the outset of COVID was almost a day didn't go by, it seemed like, where we didn't see some sort of viral, controversial social media post regarding the COVID-19 global pandemic. Simple cases of social media misconduct have become extraordinarily complicated now. Here's a good example that happened right at the beginning. This was from May of 2020, where a law firm discharged one of its administrative employees after he published this Facebook post referencing a gun and ammunition and expressing anger at retail businesses that were requiring face masks during the coronavirus pandemic. At that time, little did we know how this would continue to escalate as the pandemic continued. Here's an example that occurred in July of 2020 of a video that went viral of a Costco customer who was berating an employee who was simply trying to enforce Costco's masking policy. He was screaming, "I feel threatened, back off," and worse, he lurched in a menacing manner towards the employee who had come to the aid of an elderly woman who was asking about the man's lack of a face mask. What's interesting is shortly after that went viral, the man's insurance agency employer terminated his employment. And there was many reports indicating that the man was reportedly the highest producing sales agent in the company. This is an example of a non-work related discharge where the employer in the social media conduct was not readily identifiable. Now compare that to a scenario where you've got another non-related discharge and another employer not readily identifiable, but we're talking about social justice issues here. This was in June, where a Caucasian couple in San Francisco confronted a Filipino man who had been stenciling BLM on a wall in front of a $13 million house. The couple asked the man if he owned the home, and when the man refused to answer, the couple accused him of committing a crime by defacing property that he didn't own. Well, the man asked how they knew he didn't live in the house, to which they responded, "Well, we know who lives here, right?" Well, of course, it turns out that the man had been renting the house since 2005, but something he never told the couple during the entire interaction. Now, this being the United States in 2020 at the time, both the couple and the man recorded the entire incident, and the man's footage went viral and was portrayed as an example of racist encounter between people of color and white accusers. So in and of itself, nothing significant. Why is it relevant to the workplace? Well, shortly after the investment bank employer of the Caucasian male learned about the video, it terminated his employment. And as for the Caucasian female, the beauty subscription service through which she sold her line of cosmetics terminated their contractual relationship with her as well. Now, we also saw quite a bit of arguably work-related tweets where the employer was readily and easily identifiable. This example came from June, and it was a former employee of Facebook. And he tweeted about how Facebook had just terminated his employment. Well, what did he do? On June 2nd, he had replied to one of his coworkers' tweets that instructed the coworker to add the hashtag Black Lives Matter to the tweet. Facebook subsequently fired the employee for publicly criticizing his coworker. Interestingly enough, the former Facebook employee had been among a group of Facebook employees who had been tweeting criticism of Facebook since the employer decided not to take action against then President Trump on Facebook. Now, did he complain? Did he find that his Section 7 rights or his First Amendment rights or any other rights of his were violated? Actually, no. He posted this right after his discharge and indicated that he was not explicitly let go for speaking against the company's policies. He was fired for calling out other employee on a problematic political stance. And he doesn't doubt that Facebook's his conduct violated Facebook's respectful workplace policy. Now, we also saw non-work related posts where the employer was readily identifiable. This was in May. This was a female county prosecutor who likened protesters to zoo animals in a Facebook post. She lost her job. She later claimed that she deleted her post seconds after posting it, but someone had already screen captured the image and had begun sharing it with other county attorneys. The prosecutor subsequently posted an explanation for her prior post. It came about a day after some demonstrators had clashed with police and vandalized downtown businesses. The damage, however, was already done. The state's attorney's office had released a statement indicating that it had terminated the prosecutor effective immediately. And according to the state's attorney's office, the prosecutor's views were entirely inconsistent with the ideals and principles of that office and the duties and responsibilities of an assistant state attorney. So was that the end of it? Well, perhaps not. Shortly thereafter, the president of the County Police Benevolent Association wrote to the state's attorney's office to complain and contest the discharge. Among other things, the PBA argued that the state's attorney had treated the prosecutor differently than a male prosecutor who had claims posted similar content without consequences. But a lot of big name employers made news, perhaps in ways they didn't want. And this was a scenario where in late August, an employee created a TikTok video showing him making a, quote, Blue Lives Matter drink that allegedly contained bleach and red liquid, which he described as the blood of innocent Black men. Now, the song in the background of the TikTok video was All I Want for Christmas is a Few Dead Cops. Of course, the TikTok video went viral and an individual shared it with the employee's employer. The problem was, it was a little confusing who the employee's employer was, because although you see the cup in the TikTok video was of Starbucks, he actually was a Target employee who worked at a Starbucks within the Target. Target, of course, once the video went viral, issued this statement that the behavior of the employee was unacceptable, it violated their policies, and it discharged his employment. Oh, by the way, it also made clear that there really wasn't bleach in the drink, it was only milk and water. This I thought might be interesting for some of this audience, particularly those who practice labor law, because it was one of the more interesting uses of social media during this period of time, because I think it was certainly protected concerted activity under federal and state law. This happened on June 1. A bunch of Facebook employees staged a virtual walkout over their dissatisfaction with CEO Zuckerberg's decision not to take on a series of controversial posts from President Trump the prior week. And as part of the walkout, they took the day off of work. The action certainly got the company's attention and Mark Zuckerberg's attention. He responded by saying that Facebook needs to do more to support equality and safety for Black community through our platforms. He also pledged $10 million to groups working on racial justice. Now, fortunately, from a labor law perspective, HR was savvy enough and instructed managers not to retaliate against staff who were planning to protest or even make them use paid time off. But I think that the takeaway for me was that even in a pandemic, and even when it has to do with social justice issues, employees can and will engage in protected concerted activity. Employees are more willing to speak out now about corporate decisions with which they disagree. And that was probably true 5 years ago, but I think the last year really shined a spotlight on that. And that has led employers to be put in a situation where they're gonna have to make difficult decisions, right? They either give in to an employee's demands, particularly on the social justice front, to quell the instant unrest, or they could lose control going forward. Of course, workplaces were at the center of the social media posts this past year, several here in Michigan. I thought I would show you that we were not immune here in our state. This was a post from early July, where the owner of a popular banquet hall in Warren, Michigan, posted the following on his Facebook page. Someone screen grabbed the photo and posted it on her Facebook page. Of course, the post went viral in local news and it caused the owner to publicly apologize. Another example occurred in the public sector. This was a township firefighter in early July who commented on Facebook, on his Facebook page, BLDM, which apparently is short for Black Lives Don't Matter. in response to a national news story about a high school changing its name. And when he was questioned about it, you'll see he doubled down and stated, "Do I need to clear my throat?" And I didn't stutter. The township thereafter launched an investigation and discovered many additional issues with this employee's conduct. He had made Facebook comments about Muhammad Ali, calling him a draft dodger that may have used the N-word. He called protesters and demonstrators in Lansing riots. And he generally described protests and the BLM movement as stupid. So consequently, the township discharged the firefighter. I think one of the most notable social media developments that occurred this past year, from my perspective, was the rise of what has been referred to as alternative social media platforms. So whether it's Gab, Rumble, MeWe, even Telegram, we saw an explosion of social media platforms marketing themselves as free speech focused and unbiased alternatives to the mainstream social media platforms like Twitter, Facebook, and YouTube. The biggest one that I'm sure everyone's heard of was Parler. Parler launched in August of 2018, but it quickly became the most notable of these apps during the 2020 presidential election campaign. In late 2021, news broke about a literary agency based in New York that had discharged a literary agent merely for having opened accounts on Parler and Gab. So what if the employer didn't discharge employees who had accounts on Facebook and Twitter? My question was, would that be protected status of the employee here? Well, clearly she believes so. She thinks that she was discharged because of her religion and her political affiliation. Here's her post. Of course, in Michigan, the former is protected. The latter is perhaps not protected, but one's political affiliation may be protected in other states, particularly California. So again, more factors to think about, which really the level setting I did really provides a bit of a primer, if you will, of how to look at these things. Because as you may recall at the outset, I asked you to consider how you would address these issues if it was your responsibility to deal with them. Again, whether you're a decision maker, arbitrator, whether you represent the employees in the union capacity or as a plaintiff's lawyer, whether you represent management or the employer as a defense attorney or in-house HR representative. Ultimately, the ones on this call are the ones we're gonna be the ones who have to deal with this. And what I would submit to you is that one of the first things you're gonna need to do, particularly on the employer side, if you're going to contemplate some sort of adverse employment action, or if you're on the employee side and you're going to challenge an adverse employment action, is think through the different types of causes of action for employees or risk of liability for employers that could exist. So what I'd like to do with the remainder of the kind of substantive part of my presentation is walk you through some of the main employment issues and labor issues that you should consider when deciding, how to respond to a viral social media post regarding COVID-19 or any of the more current social justice issues. As a side note, one of the more interesting aspects of the cases I'm going to discuss is that they were all predating COVID-19 and the current iteration of the BLM movements. Yet, I think that they still provide a glimpse as how administrative agencies, courts, and even arbitrators will ultimately analyze adverse employment actions like those I just showed you over the next several years. And of course, we have to start with constitutional protections. The majority of employment issues are statutory in nature, simply because most employees are not public sector workers and don't have constitutional protection. But these constitutional scenarios still are important to understand. Generally speaking, constitutional rights only apply, as I said, to public sector workers. But I think understanding kind of the rationale behind the case law is helpful for several reasons. First, whether it's a judge, administrative agent, or a juror, they look at these constitutional principles to help guide their decision-making process, right? The proverbial, does it pass the red face test? Does it pass the, that just seems wrong test? And then the private sector often has employees that incorrectly believe that these constitutional protections apply to them, particularly their online speech. I mean, many private sector workers think they have First Amendment free speech rights. And I think maybe equally as important, the public, AKA the court of public opinion. I don't think the public really draws a distinction between private and public sector. And if you're in the position of responding to a social media post for PR reasons, perhaps on the employer side, it's going to be really helpful to understand where these lines are drawn. The First Amendment is by far the most litigated issue in this particular space, perhaps because social media in and of itself is a forum to communicate and share. When courts look at content and alleged violation of First Amendment free speech rights, they almost universally start with the Supreme Court's landmark decision in Garcetti. And under Garcetti, to be protected as a threshold matter, the employee's views must be expressed in their capacity as a citizen, not as a public employee pursuant to their official duties. And assuming the employee's speech was as a citizen, then we go into the familiar test, right? That to make out a prima facie First Amendment case, you need to show the speech was of a public concern. You have to show that there was some sort of adverse employment action, and you have to demonstrate a causal connection between the speech of a public concern and the adverse employment action. I suspect everyone on this call knows, but just to be clear, a matter of public concern typically involves an issue of social, political, or other interest to the community. A really interesting decision that came out of the Middle District of Florida a couple of years ago helps exemplify how courts look at these First Amendment social media cases. This was a case that had to do with a Florida state attorney who in March of 2017 announced that she would not be seeking the death penalty in a very high profile capital murder case. Shortly thereafter, a supervisor, McClures, in the county clerk's office, while at home, on his own time, his own computer, posted comments on his private Facebook account criticizing the Florida state attorney's decision. Specifically, he wrote on another person's Facebook page that the state attorney should, quote, get the death penalty and, quote, should be tarred and feathered if not hung from a tree. The plaintiff's comments went viral, quickly identified him as a clerk's office employee, and it probably didn't help things that the state attorney was the first African-American state attorney in Florida. The next morning, the clerk's office phones rang off the hook with complaints, mostly accusing the plaintiff McClures of being racist, although he claimed he didn't even know the state's attorney's race. He resigned, but then subsequently claimed constructive discharge. So the question is there a First Amendment violation here? What the court first did was it ran through Garcetti as it should, and concluded that the comments were not made in his capacity as a county clerk official, right? That wasn't his job to do it. So there's no question he was speaking as a matter, as a private citizen. So he already passes step one of the analysis. Then you have to look and say, were the comments he was posting a matter of a public concern? And the court went through that and looked at it and said, yeah, these are issues of social, political, or other interest to the community. These are absolutely a matter of a public concern. So his speech is protected under the First Amendment. Does that end the analysis? Does he win his lawsuit? Answer, no. Some of you who perhaps are more advanced in your careers may remember the landmark Supreme Court decision in Pickering. And Pickering provided us a balancing test to identify when protected First Amendment speech loses protection because of a more overriding interest, particularly in this case on behalf of the employer. And under the Pickering balancing test, the court looked and said, well, we agree your comments were protected speech under the First Amendment, but those comments that you made called into question your ability to discharge your duties in the clerk's office in an impartial manner. And therefore, the employer's interest in running an effective, efficient operation were harmed, and therefore the employer's interest outweighed yours. You lost your protection. The lawsuit failed. That's how the First Amendment cases in this area mostly work. By and large, I don't want to say it's completely true, but the overwhelming authority of cases of First Amendment, where they're military or paramilitary, fire person, police, of course, oftentimes people who are in any type of first responder, emergency response, ambulance, EMT people, they're often going to have a tough road to hoe, even if they're speaking in their capacity as a private citizen, even if it's a matter of public concern, because of the need for operational control of those paramilitary organizations. It will be often that the employer's needs will outweigh the employees in these social media cases. I threw this in not so much because it's social media, but it could come up in social media. And we're starting to see more and more case law where the federal Fourth Amendment becomes an issue. As you all know, the Fourth Amendment protects citizens from unreasonable searches and seizure. And these cases are starting to filter in. Sometimes you can get a hint of how courts are viewing privacy rights in the context of these Fourth Amendment cases. And since a lot of these social media posts are on an employee's own time and their own private social media post, the question is, is there some sort of Fourth Amendment protection, particularly when you start to get some of these alternative platforms, like I mentioned before, like Parler, where there's a little more privacy or protection, or if the person's on a more traditional platform like Facebook, but they only allow their page to be viewed by people who connect to them, and the employer somehow surreptitiously connects to gain access and then takes action. I think we start to see more Fourth Amendment implications. I put the Frankhauser case on here only because I thought it was interesting, and I think I could see it by extrapolation apply. This was a particular case where the plaintiff sued the employer in part for violating her Fourth Amendment rights when it accessed her personal and work documents that she had stored on her private Dropbox. Dropbox, as you may know, is a cloud-based storage service that has a free element to it as well. A lot of people store their digital stuff there. And the company moved, or excuse me, the county moved for dismissal of the Fourth Amendment claim, arguing that the employee had no expectation of privacy on her computer, which of course the county owned. But the trial court denied the motion, finding that the facts could support that unauthorized access and sharing is unconstitutional, because there's a difference, particularly in the Stored Communications Act, which I think we'll get to in a moment, where the employer may own their own data and the information contained on their own device. But once you use that device to access a third-party source, in this case, Dropbox, then there isn't consent to go there. Statutory protections really are where all the action is at litigation-wise, because again, most employees are not entitled to protection from adverse employment action under constitutional protections because they're not public sector workers and there's no state action. I want to briefly touch on some of the major statutes in this issue, at issue in this space. And then I want to identify a sample recent decision demonstrating how they're playing out in the courtroom. The first area, of course, I have to discuss is discrimination claims, whether it's race, age, gender. Social media is very prevalent in these litigations, in modern jurisprudence litigation. I think what we see a lot is, and particularly with the pandemic posts and the social justice posts, is when, under what circumstances, a specific social media post can lead to someone being a comparator for purposes of a disparate treatment claim. And I think it would also be true, although I don't say this here on my slide deck, in the just cause context for a collective bargaining agreement, when you're trying to show whether the employer is uniformly and consistently applying its policy for one of the factors for determining if there's just cause, you're always going to be having to look at the content and the context of a particular post. Morris versus City of Columbia is a really good example of that. In that particular case, the employer filed plaintiff Morris, who's a Caucasian firefighter, after he posted on Facebook that the, quote, idiots shutting down the highway better not be there when he finished work, or, quote, there's going to be some run over dumbasses. He also said that as a public service announcement, anyone who attempted to shut down the highway on his way home better hope that he's not the first car in line, because he will run them over. Well, he lost his job for those posts, and he filed a lawsuit claiming not that he didn't make them or that he lacked the right to make them, but that the employer treated him differently than similarly situated African-American coworkers. What did these alleged comparators post? Well, one posted on social media, here's a thought, I wear a blue uniform, I'm black, but because I wear the uniform, gangs are going to try and take me out. Guess Black lives don't matter now, do they? See, it's all bull s. But can't tell idiots that now, can you? The other posted, protesting is your right and you're free to do so. But when you protest in the street, that is impeding traffic. In that case, you're just pretending to be a speed bump. Neither of those African-American co-worker firefighters were discharged for their posts. So the question is, were those applicable comparators who weren't fired for conduct that was substantially similar to the Caucasian firefighter who was fired? Court said, yeah, they are sufficiently similarly situated posts, and it denied the employer's motion for summary judgment. So for me, I think the takeaway is that even in social media, similarly situated does not have to mean precisely the same. The court noted that the employees were subject to the same policies and procedures governing responsible use of social media, and the employer stated that it had a zero tolerance policy for actions that were taken to communicate or demonstrate disrespect for others' lives and safety. Well, maybe it was zero-ish, right? Because it was for some, not others. I think, however, ultimately employers still may discharge employees for inappropriate and racist social media posts, but it would help to have a work rule that governs such behavior. And it would help even more, of course, to apply those rules uniformly. The other case I wanted to mention talks about this tension that's existed for a while between religious freedoms and statutory rights. That tension is not necessarily new. We've seen that in the court for quite some time now. But what is new is that tension's become heightened via social media. Carter versus Transportation Workers Union of America from a couple of years ago is a really good example of how this tension is played out in courts. The plaintiff was a flight attendant for Southwest Airlines, and she technically was represented by the union, but she was not a member. In fact, at the time of her discharge, she was feuding with the union leadership. She had noticed that the union and several Southwest airline attendants had attended the Women's March event in Washington, D.C. that was sponsored in part by Planned Parenthood. She claimed that she's a Christian who believes that abortion goes against teachings of the Bible and the will of God. So she posted several messages on Facebook regarding the union and Southwest Airlines employees who participated in the march. Southwest Airlines learned about the message and it discharged her for violating its social media, anti-bullying, and anti-sex harassment policies because she was identifiable in her posts as a Southwest Airlines employee, and she represented the employer in a manner that disparaged the flight attendants and all Southwest Airlines employees. She filed a grievance. She lost. She then filed her lawsuit, and she claimed, among other things, that Southwest Airlines and the union discriminated against her for her religious beliefs and practices in violation of Title VII. The court denied the employer's motion to dismiss as the Title VII claim and held that the plaintiff had established more than a sheer possibility that her religious beliefs and practices were a factor in Southwest Airlines' decision to terminate her, and whether accommodating those religious beliefs would pose an undue hardship was a very fact-intensive inquiry that was better left for the motion for summary judgment stage. We're also seeing a ton of cases where social media is playing out in a very prominent role in these hostile environment harassment cases. The evidence is often identifiable, right? Because the poster's name is right on their whatever social media they're using. It's dated and it's time-stamped. A really good example of how this is playing out is the Chinnery case against American Airlines. In that case, the plaintiff alleged that several of her fellow flight attendants, I got this thing, I guess, with flight attendants today, had posted offensive remarks about her on Facebook during her unsuccessful campaign to become the local union president. And the company, she claimed, failed to adequately investigate her claims. So she alleged sex harassment. Well, what were the posts that were at issue? There were two. The first one said, "This is war. The incumbent union leaders are my friends. If you F with my friends, you F with me, and I don't like being F'd with." And then she put a picture of the Wicked Witch of the West with a caption, "I don't have time for basic B word." The court held that Facebook comments were posted about her weren't so extreme that they changed the conditions of her employment. And while some of them may have been offensive, They only constituted offhand comments and isolated incidents that were insufficiently extreme to affect her employment. I don't know how to say this, the Sequitieri versus Piedmont Airlines case is another good example of how this is playing out in harassment. This was actually a race harassment case where the plaintiff said that her coworkers referred to her as a racist that created a hostile work environment for her. She had posted comments on her Facebook page in support of police in reference to the Black Lives Matter movement. Again, remember, this is from 2018. So this conduct occurred during maybe the first rise or iteration of the Black Lives Matter movement. She had claimed that following the post, her coworkers harassed her online and at work. They called her a racist, but the court rejected the claim, saying that calling someone a racist in and of itself is not racial on its face because it's not related to a person's race. And the alleged harassment at issue here was based on the perception that she was racist, not because of her race. Moreover, alleged name calling is not severe and pervasive. So for me, what these cases are teaching is that not every slight or comment or a coworker's mean act will create a hostile work environment as a matter of law. And of course, uttering the word racist in and of itself is not because of race, and therefore is not prohibited by civil rights statutes, Title VII and the Michigan Elliott Larson Civil Rights Act. It should now be pretty obvious that conduct in the on social media can give the employer notice of protected category or their protected activity that they otherwise wouldn't have. And this is particularly true in the retaliation context where we've got, a whistleblowing claim, maybe a Family Medical Leave Act request claim, Title VII opposition or participation activity. All this is out there in the open, and it's quite the fodder for retaliation claims. We saw quite a bit of activity in this over the last couple of years as well, and I think that it's beyond dispute now that even on social media, to be protected, particularly where it's under the Title VII discrimination opposition prong, that conduct has to oppose conduct that is made unlawful by the statute. Case in our backyard, Higbee versus Eastern Michigan University is a good example of how that plays out. Because in that case, the plaintiff had posted comments on Facebook about a year after two incidents involving racist graffiti on the campus spurred a bunch of student protests. What happened was that the plaintiff criticized the university administrators for their handling of the situation, which included disciplining some of the student protesters for refusing to leave a building that was being closed for the day. He had called the administrators the HNNC. The university suspended the plaintiff, claiming that the phrase commonly was understood to mean head N-word in charge. While the plaintiff actually teaches courses on Black history, said that scholars in the field understand that phrase to mean head Negro in charge. The court said that, hey, we don't need to delve into what the meaning of the HNNC actually means, because regardless of what it means, your post isn't protected activity that supports retaliation. You weren't opposing, plaintiff, any illegal behavior under Michigan law. It only stated that the students who objected to racism were being needlessly alienated. But people who object to racism are not a protected class. Interestingly, unlike that other case I mentioned, this plaintiff also filed a grievance through his union grievance process, and his discharge was reversed through the grievance. So while he didn't have a viable Title VII retaliation claim, the decision was found to be not for just cause. And one of the big questions I think that comes out of the current events is whether employees sharing their opinions regarding the pandemic, including everything from safety measures and masks and rules, and or social justice issues like BLM, are engaging in Title VII protected activity. Is this participation? Is this opposition? Simply displaying your support for a social movement or your position about vaccines or masks or, Dr. Fauci, whatever it may be. Right now, we've got quite a few cases working through the court system, and I'm pretty sure that by next year, we'll have some good guidance on where we're at in that space. There is, however, one agency that is very interested in providing guidance now on those issues. Similar to Title VII, there is a question as to whether employees who share on social media their opinions regarding movements like Black Lives Matter or COVID-19 safety procedures are engaging in protected concerted activity under the National Labor Relations Act and under our state law counterpart. Officially, I'll say, well, maybe it's not officially. Prior to this year, the last time the board took a deep dive into this issue was in 2008. The then general counsel of NLRB was Ronald Meisberg, and he issued a memorandum called GC 0810. I commend all of you to Google it and download it. It's a really good read. It specifically relates to ULPs or unfair labor practice charges involving political activity. And what Meisberg concluded in his memo was that for employee advocacy to be protected under Section 7's mutual aid or protection clause, there has to be a direct nexus between the subject of the advocacy and a specifically identified employment concern of the participating employees. So, you know, a lot of us in this industry were wondering how this would apply to the newer iteration of speech or advocacy on social media or otherwise, but for purposes of this presentation, social media, regarding things like the new iteration of Black Lives Matter or COVID. If the employee complains on social media that the employer isn't implementing proper safety protocols, probably not. Social PCA, maybe. But what if they're advocating about Black Lives Matter? Is that supporting a movement that's political and independent? Or is there a nexus between that advocacy and the employment? Well, signaling its position that employee advocacy may change, earlier this year, the acting general counsel of NLRB, Peter Sung-Orr, published a new memo. That's GC 2103, also available online. Also strongly suggest you download a copy and look at it. And I think acting GC Gore has made the case that employees' political and social justice advocacy will be re-reviewed under current standards, and it will be looked at when looking at whether the advocacy itself has a goal of mutual aid or protection. It will focus specifically, it being the board, on whether the subject matter has a direct nexus to the employee's interest as employees. So, for example, if a hotel employee had an interview with a journalist about how earning minimum wage affected her and employees like her, or how minimum wage legislation would affect them, and there's no question that's going to be viewed as protected. I suspect that the NLRB will also take the position, particularly when the new board member, Gwen, I'm drawing a blank on Gwen's last name, the new Democratic nominee from President Biden gets appointed, Wilcox. And ultimately, when they have the majority of the board, we'll see a push to identify how these political and social justice movements in society have grown so large that they also involve the workplace, and therefore employers may be acting at their peril with policies prohibiting the support of these movements, including on social media. Probably just to tie one loose end out, in late 2019, the board issued its Caesars Entertainment decision. For those who practice labor law, you may know that in 2014, the Obama board issued a decision called Purple Communications, which held that employers must presumptively allow employees to use company email for Section 7 activities. And those of us in that space who advise on this, readily believe that it wasn't limited just to email. It was all employer communications. So if your employee was using your workplace internet service provider and computer to post on social media, that would probably be protected under Purple Communications, just as if it was the email. But the Caesars Entertainment decision, which was issued, as I said, in late 2019, reversed Purple Communications and said that employees do not have a statutory right to use employees' email and other information technology resources to engage in non-work related communications. Rather, employers have the right to control the use of that equipment, including email IT systems, and they can lawfully exercise the right to restrict the users to work-related times, provided they're not doing so to discriminate against activities protected by Section 7. That's another case that should be on your radar. I suspect we'll see some activity there with the current administration as well, perhaps going back to the Purple Communications Standard and expanding it. As I promised, I wanted to leave 10 minutes or so for a discussion or questions, and now would be a really good time to do that if you have any.
So you can either just unmute and ask your question, or you can put it in the chat, and between me and Adam and Emily, we'll get to it. I did have one question I wanted to kick off the discussion with. In the Facebook case where there was the virtual strike, was that considered by HR to be an unfair labor practice strike?
No, I don't think they viewed it as unfair labor practice. I think it was just viewed to be protected activity because it was for mutual aid or protection. So it was Section 7 protected activity. No different than if, the employees said, hey, we want to go support Fight for 15. What made it interesting, I think, for me was this was a virtual strike because we're all in the world of Zoom. So they said, okay, our equivalent of leaving the workplace is not participating in Zoom today. We will not be online.
One other thing is all of our presentations are recorded, and you can replay these recordings by going to our National LERA website, leraweb.org, and look for our chapter. Also, Adam, there was a chock full of information in here, and I know you've done some writing in this. Would you make available to anybody that requests it, some of your writing in these areas?
Yeah. Of course. I'm at Epstein Becker. You can Google me. My email's there. It's A Forman, so A F-O-R-M-A-N at EBG Law, Epstein Becker Green Law, ebglaw.com. Happy to share some white papers. Actually, if you have PLI, is it PLI? I write a lot. So there's a publication called Social Media and Law by Practicing Law Institute. I have a chapter in there that goes specifically on how social media is used. I also have a chapter in ICLE's Employment Law in Michigan, where I talk about social media in the workplace as well. That may be more accessible to those here locally. ICLE publishes it.
Oh, I can see that Emily or Rhea put on the link for any of the replays of our presentations over this last 6 months. Doyle, you have something?
Yeah, I just thought I would offer a probably not too enlightening observation. I've heard a couple of arbitration cases involving social media, and it matters to have a policy. That seems sort of straightforward, but it matters to have a policy and to understand your own policy. I had one case involving an arguably offensive social media post where the employer had a social media policy which prohibited only on-duty posts, regulated on-duty posts. And as Adam mentioned, such posts have timestamps. And they fire a guy. The proofs at hearing are, what time do you go to lunch? 11:30. What time was the post? 11:38. And the case just falls apart. I had another one with a multinational corporation on a Black Lives Matter, run them over in the highway Facebook post, where the employer had no social media policy. And the case really hinged on that. They had no policy at all. It was a standard just cause under a collective bargaining agreement. The employer couldn't show that there was a rule. There was no particular nexus to the workplace, although if you hunted, you could maybe figure out that the guy worked for a subsidiary of a multinational corporation. So, the process matters, having rules matters, applying them actually matters, much in the way of other just cause cases. So.
Steve, you have your hand up, go ahead.
Yeah, so just sort of picking up on Doyle's cases, comments, cases I've either done as employer advocate or as an arbitrator. The tricky part can be initially when the employer is investigating to get the employee to admit, or does the employee admit that it was him that posted it? Because if I could post something as Adam Forman. It doesn't mean that Adam Forman at outlook.com. It doesn't mean that Adam S. Forman was actually the one doing it. I actually had a case as an arbitrator where the employee denied that was her name in an email, but that wasn't her. Second thing, having worked on lots of policies, it's really hard to make them non-legalistic and make them, because the best you can do are guidelines and make them understandable and not too long that employees won't read them just because they're so blooming long. Third thing is I find with as an advisor to employers, it's often good to take a deep breath. That in the same way that the employee is mad and sits down and vents on the computer and sends it out, and then it's out and they can't control it, like one of your first examples, the employer frequently overreacts to the situation, and sometimes you need to just take a deep breath and go, how bad was this? But this seems, I think this is the third time at least that Adam's done this presentation, and I guess he does nothing else but read social media, and they're always amazing. I commend you, but this just keeps expanding. And as long as people get angry or have opinions, they're going to do stuff that offends somebody else when they read it. And it's often very, very gray whether it affects the employer or not, particularly if it's a public employer and you have a public employee commenting on something that has nothing to do with the city of X, except that people know that person works for the city of X. So Adam, come back in a year. You're going to have completely different material next year. But this is always one of the best LERA presentations for the year.
I have to echo Steve's accolades for you. This is one of the most informative LERA presentations we have whenever you come. So thank you so much. We're closing now in the next 30 seconds or so. I want to thank everybody for having participated, not only in this presentation, but all the virtual presentations we've had. And we'll see you again in September. Adam, thank you so much. And LERA community, see you soon.
Thanks, everyone.